Hi, my name's Laura Banks and I'm a partner in the private client team based predominantly in the Birmingham office. So obviously a very overriding question that people often have is how do you pass assets on effectively during your lifetime or indeed on your death? Looking at the essentials of estate planning, what you need to think about is obviously inheritance tax, because that's the main tax that looks at your assets. When you die, all your assets are added up. And it's not just the assets, for example, your bank account, your house, investments and so on, but your executors will also have to declare gifts that you have made in the last 7 years. So part of that is thinking about making the gifts, but before that, in your lifetime, you need to have thought about what you can afford to give away, so what you don't need. And you have to balance tax efficiency with your family circumstances and obviously your own priorities. You do need to gift properly. So something that people ask me quite often is, well, I'm going to give my son that Monet painting, which would be nice, but I want to keep it on my wall because I like it too much. Well, that isn't a proper gift. You give it away properly rather than keeping it, because otherwise you've retained the benefit. So when we're talking about gifting, we're talking about giving properly, so you no longer have the benefit of that asset. People ask if you can make gifts in your lifetime, and the answer is yes. And there are various exemptions and allowances. So you have, as an individual, an allowance of £3,000 a year that you can give tax-free, and that can be to anyone. That isn't £3,000 to each member of your family, but that's £3,000 in total from you. You can also give a small gifts exemption, and that's £250, but that has to be to someone different than to the other people who get the £3,000 or that amount divided between them. There are allowances for making gifts in consideration of weddings, and that is different amounts depending on the relationship. You can also gift your excess income inheritance tax-free, but that's quite a complicated exemption to come within and can involve quite a lot of paperwork being produced and numbers being crunched. You can give any amount you want. So I've mentioned £3,000, but you can give a much higher amount. It's just that only £3,000 a year would be exempt, and you have to survive that gift by a further 7 years for it to drop out of being taken into account when you die. So if you've made gifts in the last 7 years of, for example, £100,000 to various family members and your own assets are £400,000, if you die within the 7 years of all those gifts, then you're not worth £400,000 for the taxman, you're worth the £500,000. But once you start outliving those gifts by 7 years, they slowly drop off. So I liken it to a conveyor belt. It goes on the conveyor belt and after 7 years it's dropped off. There is a slight complication with 14 years being taken into account, but that's where you need specialist advice. So people ask if they can give to a trust rather to an individual. Perhaps they don't think the child is responsible enough, even though they're adult, to receive the money. You can of course give to a trust, but it comes with potentially an immediate tax charge. So if you gift over £325,000 in one go, then that gives rise to an immediate charge at 20% on the balance over £325,000. So it is a complicating factor. There are other factors though that you need to take into account if you're thinking of making a gift. It shouldn't just be about the tax implications. For example, can you afford to give that money away? I always recommend that with your financial advisor, you conduct what's called a cash flow forecast. So as best you can, and obviously none of us particularly anticipated the rise in energy costs, but you try and analyse what your future cash needs will be. If there's an obvious surplus, that might reassure you that you can afford to give it away. But you need to bear in mind that it's your money and you should decide what you do with it, because you might need to have that money to spend on you in the future. It isn't possible for you to have that money back, not unless the recipient is willing to give it back, but of course they may have spent that, so not be able to give it back even if they were willing. So sometimes you might want to consider giving into trust, although I mentioned there are tax implications, particularly, for example, to protect that money. The recipient, if they receive money and then they die, it can go under their will or the intestacy rules to people you don't want it to go to. They might divorce, where obviously that money then is in the matrimonial pot to be thought about, or they might be made bankrupt. So there are ways of protecting it to a lesser or greater degree by giving to a trust. If you still want to think about giving to an adult child, part of the negotiation of that gift is suggesting quite strongly to your child that if they're not married, they have a prenuptial agreement, or if they are married, they have a postnuptial agreement, which tries to ring fence and discuss and agree in advance what would happen to any monies of the parties when they divorce. If you think that gifts aren't for you in your lifetime, you can't afford to do them or just don't want to take the risk, I'm asked if there's anything you can do in your will. And the answer is yes, and really it needs to be a tandem approach of thinking what you can do in your lifetime and also how you want provisions in your will to cover what happens on your death. So you might want to consider, if you don't want a lifetime trust that you set up and fund, but you do want a trust on your death, you can have a trust in your will, for example for your children, for your grandchildren, for wider family members, and we call that a dynasty trust, which makes it sound much more exciting. But essentially it means that it can run for 125 years as a maximum period, and that can look after family members or indeed anyone else that you want to include in the trust. It's very important, if you're a couple, to think about having a trust in your will anyway, in all or only some of your assets for the survivor, and that can protect against care fees eating up all of the money that's yours. But where you have a blended family, so it's second marriage, for example, or second main relationship, and there are children either from your first or previous relationships and or together, it's important there to think about a trust on first death so that it protects the capital and you can control how much goes to your surviving partner or spouse so that they are adequately provided for, but also protecting some or all of the capital so that you know that it will go to your children, for example. If, of course, you haven't done the sensible thing, as I would think it, and sorted anything out in your will, if you get to the point of being an executor and you're looking at someone's estate, there are still steps that you can undertake. So, for example, as an executor, you need to be looking to claim the nil rate band and the residence nil rate band if they're available. And if it's the second of a couple to die, you should be looking at claiming the transferable nil rate band and transferable residence nil rate band. But obviously you need to get advice on whether those are possible or available. It is possible for beneficiaries to enter into what's called a deed of variation, so they vary what interest they receive, and they between them can rejig the will to leave it in a different way. But for example, if you're asking the spouse to give up money to adult children, it obviously is only if the spouse is willing to do this. Whereas if you gave money in a certain way to your adult children in your will, then those legacies would be what happened whether your spouse liked it or not. Although obviously they can sue your estate if it really came to it. But this is why you need expert advice. So in all, I would say it's possible to maximise your efficiency and think about gifting assets or looking at what you do in your will, but you do need to start thinking about it, both your lifetime position, the position on your death, but if you're dealing with an estate, do still look at what's possible and do get professional advice from someone suitably qualified. So I appreciate that there's an awful lot to absorb and take in there, and it is very much specific to the individuals and their circumstances, their assets, their family, how those people are and what you want to do. So if you have any further questions, please don't hesitate to get in contact with me and I'd be delighted to talk about it further with you. Thank you.